50 hand recount. Not all for Gore, not all for Bush, but
Yeah.
a total of 436.
I just don't have that number in mind. I just don't have that number in mind.
More than 100 were added, weren't they?
That's my understanding and recollection.
You recollect more than 400 were added, don't you?
I don't even recall what the number was, but I know there was more than 300.
I'm in the ballpark.
Okay, you are.
Now, some of those were added for Vice President Gore, some of them were added for Governor Bush.
That's correct.
And as best you could tell, whether you disagreed with the system and what was being done as far as the law and that, whatever was done, it was fairly being done as best you could tell.
I don't think that it was fairly being done. No, I don't. I disagree with that. I think
Was
that
it honestly being done?
I think.
Your Honor, excuse me. I'm sorry.
Ask him, ask him.
Yeah, without order, excuse me. I won't do. Thank you.
Did you ever observe anything going on in this recount that you thought was dishonest?
Excuse me, Your Honor. It's the same question I judge.
Your Honor,
I believe he's answered that about 4 times now.
May I ask you a question now?
No, sir. Go ahead, proceed. Rephrase then if you need to.
Okay. I'm just, what I want to know, Mr. Spencer, and I don't mean to belabor it, is where you disagreed with how something was done, we're not suggesting that any dishonesty was going on.
No, not to the best of my knowledge.
There. Now, as you understand it, but for time constraints placed by the Supreme Court at that time, all of the undervotes would have been hand recounted, wouldn't it?
My understanding is that but for the deadline, all of the all of the votes would have been manually examined and counted by the canvassing board.
And even on the day the canvassing board decided not to continue the manual recount because of time, that very morning they had voted 3-0 to do the undervote, count the undervote by hand, didn't it?
Yes.
The entire undervote by hand.
Yes.
Now, are we correct when we say these approximately 9,000 undervotes that were not the subject of the manual recount have never been observed for counting purposes by human eyes?
To the best of my knowledge, that's true.
In fact, you have absolutely no evidence to the contrary that anyone ever did attempt to recount them by hand.
That's correct.
Now, when we get to the question of, you told us that first there was a vote to do the simple hand recount of the ballots. Then that was stopped. They voted to stop that, correct? Then they voted to continue the hand recount. Am I correct?
That is correct.
And when they voted to recontinue, they at least had before them for their consideration an affidavit of a statistician, Professor Carroll from Johns Hopkins. They had that before them for their consideration, didn't they?
I recall there was a lot before them for their consideration.
So you're not suggesting to Judge Sauls that just out of nowhere they decided all of a sudden, by golly, we're going to start back with no reason whatsoever?
Absolutely not. I think that every decision that they made was very carefully considered.
Now, you gave us your insights, sir, Mr. Spencer, as a longtime Republican in Dade County of how you thought the hand count would have gone if it had continued from these precincts to those precincts and about the county, correct?
Well, what I indicated was, just to be correct, that the count, the manual recount, so far as it went, was virtually only in the heavily Democratic areas. And it really didn't take into consideration the heavily Republican areas, or even those which were evenly mixed.
But we will never know what that recount would have shown because it hasn't been done, correct?
That's correct. The entire manual recount was never completed properly.
And can a commercial lawyer and a trial lawyer agree that the only way we'll know for sure what these 9,000 undervotes that have never been viewed for counting purposes by human beings, the only way we'll know what they actually say is if someone counts them.
Well, that's where we disagree. I contend that these votes have been counted. I think that they have been fairly recounted, and that these votes, by virtue of the results of the tabulation equipment, there was no error, and that the results which have been certified by the canvassing board are the fair, proper, and legal results of the election in Miami-Dade County on November the 7th.
Okay. Would
That's
you
my
agree
view.
with me that they have not been hand counted?
I would say that
Excuse me, sir. Asked and answered, Your Honor. It's repetitious. He'd already said that they've not been.
Rephrase
counted
your
by-
question. I believe he's testified that they haven't been hand counted. I think that's, y'all
I
agreed
told
on
this
that.
very much. Mr. Spencer, you've told us why you don't think these 9,000 votes should be manually counted. Would you agree that if Mr. John Almond, I believe his name's pronounced, the manufacturer or the inventor of the voting apparatus that was used, says that in a close vote, a hand recount is important? Would you defer to him on the question of whether we could better know what those votes said if we hand recount?
no, sir, I wouldn't, because the results of an election for the office of President of the United States of America needs to be fair and even-handed, and to simply count votes from predominantly Democratic precincts, or even to use a system of hand observation just in Dade County, or just in Dade, Broward, and Palm Beach County, and not do the same throughout the rest of the state of Florida, is going to give a skewed result and an unfair result, and is not the kind of result that our system is set up for. So I respectfully disagree.
And that's your opinion? It's your legal opinion? It's your political opinion?
Yes, sir.
Object to the sidebar from counsel, Your Honor.
I'm asking him if that's what it is. It is.
It is all of those, sir.
Thank you very much.
No redirect, Your Honor.
Well, if you don't mind, let me ask one question. You made reference to difficulties down there and in the manner in which they were implementing, I suppose, the hand count when it was started. Is that correct?
Yes, sir.
Well, were you able to tell, or do you have any? Well, just let me leave it at that. Were you able to tell what kind of system that or standards that the board was using when they began counting and counted the approximately 15 or 20% of the first numbered precincts?
Yes, sir.
What was
I did. I should explain that I was behind the canvassing board watching them.
All right.
It's about as close as I am to the computer screen here. And essentially what happened was that there were different variations of decisions that I observed. For example, my observation of Judge King was that if there were simply a dimple or a pregnant Chad of any kind, he would determine that that was a vote regardless of whether or not there were indentations or clear punches on the rest of the card. On the other hand, I observed that Supervisor Leahy on the full manual recount used a different approach. I observed that he would take the ballot and hold it up to the light, like I am indicating here, and look to see whether or not there was some separation on the top of the ballot, light separation of some type. And if there were, then, and there were some other indication on the ballot, he would determine that that was a vote. Judge Lear used a different approach, and she would take the ballot and and hold it to the front and also turn it over on the back to see whether or not there was some paper separation. This was different than the process they used on the first go-round on the 3 precincts. And I saw all kinds of different variations of these indications, and I reached the conclusion that there was no standard that was being used, but that there were different approaches being used by each of the 3 of them.
Well, even if that was the case, when they decided after they reviewed it to place one in the stack that would count as a vote, were they unanimous when they did that?
No, Your Honor. They, in some instances, where there were clear punches, they were unanimous, and we did have several of those. But most of the time, it was a 2-to-1 vote. I saw a majority vote, and I would say that the vast majority of the judgments I saw there were by majority vote, not by unanimous decision.
Was it the same majority, or did the majority vary?
The majority varied. It was, in certain circumstances, Judge King would use sort of a dimple test, and one of the other, Leahy or Lair, would go along with him. And then in other cases, I noticed that Judge Lair would say that there was no other indication on the ballot of a voter's intent to actually vote, and she didn't think that there was that kind of indication.
Well, the majority changed. Did the one ever change?
No. The one consistency that I would observe and that I recall was that Judge King seemed to see a vote in every dimple.
No, I'm talking about if it were 2-to-1, we're dealing with a majority. I'm talking about the one. Did the one always stay the same, or did the one move around the table among the 3 of them?
No, the one moved around.
Okay, all right. Okay, so if you have a system like you've described, even if you have a count, suppose would it be the case if you put 3 different people in, then they might get a different count from the 3 people that you observed?
Absolutely, and I must tell you, Your Honor, that the judgments that I observed on the second go-round were completely different than the system which was used on the 3 precincts in this sense. On the first go-round, Supervisor Leahy did not hold the ballots up to the side. What he did was to look at the ballot, and he would look to see whether or not there were clear punches on the rest of the races. And if there was a hanging chad by 2 points, he would determine that there was a vote because the voter had clear punched on the rest of the ballot, and that was his decision. Judge King, as I said, was fairly consistent. If there were a dimple, regardless of what the rest of the vote was, he would determine that there might or would be a vote, and he would vote for that. And Judge Lair, I noticed that she would make a decision for a vote only if there was an actual clear tearing away of the paper on the ballot, on the chad. And so I noticed and reported a completely different set of criteria, if I could use that, between the 3 precincts and the last manual recount.
Okay. All right, so thank you. All right. Either of you may inquire as to any matter I may have inquired about.
I have no questions, Your Honor.
No questions, Your Honor.
All right. May the witness stand down.
Yes,
Be
sir.
excused without objection.
Your Honor, at this time, Governor